Welcome to our session on the Charities Act 2022. I'm Shivaji Shiva, partner in the charities team at BWV, and this is...
Hi, I'm Rebecca Young, and I'm a solicitor in the charities team.
And we're here today, as you'll know, to talk about the changes being made by the Charities Act and the practical implications of those changes for your charities. We're going to go for about 40 minutes. There'll be time for a bit of for some questions and answers after that. And what we're hoping to do is just to review the implementation timetable, and then have a look at, in particular, the changes that are to be introduced this autumn before considering any questions that you might have. So to move on. The background to the Act is probably quite well known, but just briefly, what we had was the Hodgson Review of the Charities Act 2006, which was then a kind of innovative approach to looking at whether that Act had been well implemented and whether there had been problems emerging from it. That took place in 2011-12. That was followed by a Law Commission report on selective issues, so technical issues in charity law, which reported in 2017. And I'm pleased to say that some members of the team here at BWV, not me, I guess to say, I joined the firm at that time, but others were involved in advising the Commission at the time. And that produced a range of measured recommendations for improving charity law and making it more efficient and effective. The government issued its response. That took us forward to March 21, in which it accepted most of the recommendations made by the Law Commission, resisting just a few. Not as much change was made to the situation on land transactions, where there had been suggestions that changes as dramatic as removing entirely the need to get a qualified surveyor's report before selling land might happen. It didn't go as far as that. There are some proposals to change the rules on Section 115 consent, that is the consent that has to be obtained from the Charity Commission before engaging in litigation about internal disputes, where there had been a suggestion that the Commission shouldn't be dealing with those applications for consent where it in itself was conflicted, and that didn't go ahead. And then finally, there were some other changes around the way in which changes to the objects of organisations were handled, which again were resisted. But broadly, those were accepted. And because a bill had been suggested in the Law Commission report, we moved very quickly to the Charities Act, which came in earlier this year. And we're now looking at the implementation of that Act, which is due to happen in autumn 2022, i.e. about now, in spring next year, and then in autumn next year, to allow the Commission time to complete its review of its guidance and the other steps required to introduce those changes. These changes aren't about new enforcement powers for the Commission, so we're not seeing changes of that sort. But there are some potentially major changes that organisations will want to take note of, including the opportunity to simplify the process where disposing of land and to streamline processes followed where amending governing documents. Can we move on to the next slide, please?
Thanks, Shivaji. Yeah, so as Shivaji said, the plan is to implement the changes through a period from this year to autumn 2023. So some key changes to look out for. Expected this autumn, there's some changes to simplify the process for dealing with failed appeals, so Excretia Payments. There's some changes in relation to ex-gratia payments, and also around the power to pay trustees for goods and services. So those ones we're specifically going to cover in this webinar, so you'll have further detail on those shortly. Looking further ahead, to spring 2023, there are changes to the permanent endowments process. So the changes would give trustees of permanent endowed charities more flexibility when dealing with their charity funds, including a new para to borrow up to 25% of the permanent endowment, which would be repayable within 20 years. And also to give wider discretion to trustees operating a total return approach to investment. So some flexibility there. And then further ahead in autumn 2023, there's some planned changes in relation to the register of mergers, which would look to resolve certain inconsistencies currently in the law. So to explain a bit further, for those of you who've not come across the register of mergers at present, the changes brought about by the 2006 Act were intended to remove the need to hold on to shell companies to catch legacies following a charity merger. But this didn't quite work out, and in reality there are some practical barriers to the process. So the amendment is aimed at resolving those discrepancies and should simplify the process going forward. So as we said, they're planned in spring 2023 and autumn 2023, and we are planning some further webinars to cover each of those implementation phases, so you'll have more detail on those as and when those future webinars come around.
So other highlights of the period that we're due to follow include in spring next year, we've got the changes coming up in relation to the disposal of charity land, and in particular the ability to use a wider range of professionals where organisations are disposing of land, including potentially employed advisors, and given that, the need to consider changes to internal processes to deal with those disposals. And then we have later in the autumn the move across to a harmonised approach from the Charity Commission to dealing with changes to charity constitutions, with the simplification that should bring to those individuals who might otherwise have found it a little bit off-putting to have to deal with the different requirements depending on whether your charity is established as a trust, as a charitable company, or in another manner, and where what we'll see is a unified approach in which the Commission will consider whether the purpose is consistent with, and there's a need to change it in a way that's as close as possible to the current purpose, and that it's a suitable and effective change moving forward.
That was sort of a whistle-stop tour of the key changes to look out for. We're now going to go into a bit more detail about each of the changes that are planned to be implemented in autumn 2023, with the caveat that at present we don't have any further update from the Commission as to when those are expected. So it's a case of keeping an eye out for further information and for further guidance from the Commission on each of those changes. We do have a poll before I go into these, just to gauge sort of the different charity structures we've got in the room and how this might be relevant to the changes. So yeah, just to let us know how your charity is established, so we can gauge the room. That's great, thank you. So as you can see, we've got a bit of a mix here, as I think is expected. Charitable companies make up most of the virtual room, but we do actually have a good mix of each structure there, so that's nice to see. So the first amendment we're going to discuss is in relation to Royal Charter charities, and we do have a few in the virtual room. So the changes here will change how Royal Charter charities can make amendments to their governing document. Royal Charter charities aren't as common as corporate structures. For example, they're mainly found in the education sphere, so universities, to give an example. And this change means that Royal Charter charities that don't currently have an express provision in their governing document to make amendments will be able to make amendments to any provision within their charter by way of passing a resolution. That resolution will be subject to Privy Council approval, but the resolution themselves will be sufficient to amend the charter. This should hopefully streamline the process for Royal Charter charities. We know from experience in advising Royal Charter charities that the current regime making amendments can be quite difficult and long drawn out process where there's no express provision in the governing document, as you currently have to petition for a supplemental charter. So it should hopefully make the process a lot easier. Next slide. Thank you. So the next sort of change we're going to discuss is in relation to charities established by Acts of Parliament, which again aren't very common, but I know we do have a couple in the room, so that's good to see. So the changes here will sort of make it easier, again, for charities established by Acts of Parliament to make amendments to their governing document. For those of you who've never come across a charity established by Act of Parliament before, as I said, they're not very common, mostly historical, established during a particular period, and often sort of promoting issues that might be promoted by the establishment. So to give some examples, the National Trust is established by Act of Parliament, as is the Shakespeare Birthplace Trust. So that gives you an example of the types of issues that Acts of Parliament charities relate to. So the change that's coming into effect will mean that charities established by Acts of Parliament that want to make changes to their governing document, the process will be slightly different, and it will be subject to a lighter touch parliamentary process. So to explain, an Act of Parliament charity can be established by a public Act of Parliament or a private Act of Parliament, and there's a slightly different approval process required for each. Notably, at present, charities established by a public Act of Parliament are required to go through what's called an affirmative process, which means that a resolution approving the change to the governing document is required from both Houses of Parliament, which, as you can imagine, is a long drawn out and often difficult process that means changes can be difficult to achieve. The changes will mean that all Acts of Parliament charities, regardless of whether it's public or private, will be subject to the lighter touch approach. So that resolution process from both Houses of Parliament won't be required, which again should reduce waiting times and costs and help sort of simplify the process. Another key element here is that once an Act of Parliament change is approved, further amendments can be made without the parliamentary approval process, which again will also be beneficial. Next slide, please. So the next change to discuss is in relation to CPRE powers. For those of you who've not come across that term before and may not be familiar with the process, to apply a payment CPRE means to transfer to another charitable purpose, which is as close as possible to the purpose for which the money was originally donated. So the changes planned here will give trustees additional powers in certain situations to make payment CPRE. That's most notably around dealing with donations from failed appeals. So that might be, for example, where appeals don't raise the amount of money that was required to deliver the aim you wanted to achieve, or where a charity raises too much money and there's spare funds left over once you've met that need, or where the circumstances change and you can't use the donations for the specific purpose you intended. So in those types of situations, you may be able to apply it for a similar purpose. There are certain conditions that need to be met for you to be able to do this. That includes where it would be unreasonable to incur the expense to return the donation, or where it would be unreasonable for you to be expected to return the donation, where the donation is £120 or less, where the donors can't be identified or found. And those situations where you meet those tests, you can apply the payment CPRE without seeking Charity Commission approval. So for charities who regularly make appeals for donations, this will, of course, simplify the process. For example, current requirements could require a charity to wait up to 6 months for a donor to request a refund before making an application to apply the payment CPRE. And currently you need a scheme from the Charity Commission to make a CPRE payment. So this will obviously simplify the process for smaller donations. Okay, next slide. So the next point we're going to discuss is the changes in relation to remuneration of trustees for goods or services. We do have another poll here for you, just to gauge, so whether any of you have ever or currently pay any of your trustees for goods or services. Okay, interesting. So a few of you do, but many of you currently don't, or don't have that requirement. Thank you. Okay, so for those of you that might be aware, charities do already have statutory powers in certain circumstances to pay trustees for services to the charity beyond their usual trustee duties, or for goods in relation to those services. Currently, charities can only pay one or more of their trustees or a person connected to a trustee for providing services to the charity if certain conditions are met. Currently, under the current regime, you cannot pay a trustee solely for goods provided. So the changes here will extend the powers to pay trustees so that you can pay in certain circumstances just for providing goods to the charity. So to give some examples to sort of add colour to those changes, currently you can pay a trustee for services provided. So that might be, for example, estate agency or computer consultancy services. A charity can also pay a trustee for goods related to services provided. So that might be, for example, plumbing or painting services and the parts and materials needed to provide those services. So there's a direct correlation between the goods and the services provided. But the changes will mean that in certain circumstances, trustees can also be paid solely for goods provided. So that might be, for example, stationery services, stationery provided to the charity. So the key distinction there is that those goods aren't related to a service at all, but they can be provided and the trustee remunerated for those. That's clearly a positive change for charity trustees to be able to make use of the benefits that might be within their trustee group and be able to remunerate for those services. There's also a new power for the Charity Commission to authorise trustees to retain a benefit which they've already received for work done to the charity, or to order a charity to pay a trustee for work already done, which wasn't a permitted benefit, and that will remove the need to apply for courts in those circumstances. Thank you. So the next one is changes to the Charity Commission's power to make schemes. This will extend the scheme-making powers of the court or the Charity Commission. So currently, under the existing legislation, a power to make a scheme is only applicable to charitable trusts. So the changes here will mean that the scheme-making powers will also apply to charitable companies, CIOs, and any other charitable structures. So clearly widening the reach of those powers of the Charity Commission. However, so currently charities established as a body corporate, so a company or a CIO, would usually follow a more regular constitutional power to amend the governing document, as I'm sure most of you are aware. So for example, a resolution of a company members to amend the governing document of a company. There are potential sort of human rights issues that we can foresee here in relation to the Charity Commission making a scheme and therefore bypassing the rights of the company members themselves to make those changes. So in reality, we envisage that this might not be used very much. It might be a last resort. So it may not make a practical difference to most charities. It's more aimed at sort of harmonising the procedures available for amendments and scheme making from the Charity Commission. Thank you. So the next change is in relation to trust corporation status. The new change will automatically confer trust corporation status to existing and future corporate charities in respect of any charitable trust for which they are or become a charity trustee. So to explain that a bit more for anyone that's not come across trust corporation status, it most commonly arises in restructurings or incorporations. So where a charity incorporates and the new corporate body charity becomes the sole trustee of the old charitable trust to be able to give valid receipt for proceeds of sale and deal properly with the land owned. So that trust corporation status is required for them to be able to deal with the land. This change is important because it will widen the trust corporation status and streamline the process, because the status will be automatically conferred to a charitable body corporate. At present, you're required to apply to the Charity Commission to appoint a corporate trustee and receive the trust corporation status. Practically speaking, from experience in sort of advertising on these types of issues, it's not uncommon in big restructurings with deadlines and complex procedures for this step to be missed, which can lead to issues sort of post-merger, post-restructuring, where you're required to then apply to the Charity Commission for consent to get that status to then be able to properly deal with the land and finalise the matters. It should be noted, though, that this only applies to corporate trustees who are charities. So a corporate company trustee who is not a charity will still be required to go to the Charity Commission and apply for the position. Thank you. So the next change is in relation to ex-gratia payments. So just to sort of give you more background here, for those of you that have not come across ex-gratia payments, an ex-gratia payment is essentially a payment to discharge moral obligations which neither further the charitable purposes or settle claims, and which charities are not under a legal obligation to make. So this can occur, for example, where a charity receives a legacy and there's evidence that the donor has changed their mind, or in the case of an employee, where there's a desire to make a payment beyond what is strictly required of the charity. So we have another poll here, just to engage how many of you have come across this before, just to let us know whether you have ever made an ex-gratia payment from your charity. Okay, interesting. There's some of you still not sure what that process is, and that's not uncommon if you've not had the requirement to make one of these payments before. But quite a few of you have made such a payment. So the changes here will give a new power in relation to small ex-gratia payments, where charities can make that payment without Charity Commission authorisation. So currently, authorisation is always required from the Charity Commission where a charity wants to make an ex-gratia payment. What constitutes a small ex-gratia payment will depend on the individual income of the charity, and there is a table available on the Charity Commission website. If you go through the website to look at the changes that are coming into force in autumn 2022, there is a table that sets out the different thresholds. To give some examples, a charity with a gross income of up to £25,000 will be able to make an ex-gratia payment of up to £1,000 without authorisation. Larger charities, so with a gross income of up to £1 million, will be able to make payments of £20,000 without Charity Commission consent. Any payments that are above those thresholds stated will still require Commission authority. And there's no limit on the amount of ex-gratia payments that can be made within a year, as long as they're within the thresholds. There's also a new power for trustees to be able to delegate the decision-making for ex-gratia payments to other individuals or groups within the charity. So that could be, for example, delegating the authority to make a decision to a subcommittee or to the chief executive. This will lower the burden on the charity trustees. So currently, the decision to make an ex-gratia payment must be made by the trustees as a whole. So having that ability to delegate to a subgroup to deal with that issue will be beneficial to charities who need to consider making those payments. Thank you. So another change is in relation to charity tribunal costs. And a new section will give the charity tribunal the power to make authorised costs orders. Such orders can be made in relation to current or prospective charity tribunal proceedings and appeals before the tribunal to authorise payment of costs out of charity funds. And that's costs that have been incurred or will be incurred in the future. So the order would cover the charity's own legal costs in the tribunal case, as well as any other costs that the tribunal might order the charity to pay. For those charities in the virtual room who may not have come across charity tribunal costs, who maybe cannot foresee ever needing this particular power, just to give an example of where this might come up, we've seen in our work in the past, this often comes up in relation to trustee disputes. So where you have disputes within the board of trustees of a charity, the disputes may result in a claim of defamation from one trustee against the other trustees. So the charity trustee that's subject to a defamation claim may commit large sums of money from the charity in dealing with these claims, but there may later down the line be a dispute over whether the charity trustee was validly appointed as a trustee at the time of that dispute, and therefore whether they were actually able to commit those charity funds to dealing with the claim. So as you can see, there's issues where that could be necessary to deal with charity tribunal costs there. So the individuals may need currently to apply to the court or follow a specific statutory procedure in order to get a costs order for those costs to be paid from the charity funds themselves, which can be very time consuming and often not a practical option for trustees. So the changes will hopefully help trustees to obtain costs orders in relation to the legal costs incurred in bringing or defending charity tribunal proceedings. And it also provides a direct route to the Charity Commission on such matters. So under the current regime, there's no option for trustees to apply directly to the tribunal for a costs order. As I said, there's various court or statutory procedures. So this will apply a direct route to be able to go to the Commission to deal with the issue of charity tribunal costs. Although, as I mentioned, some of you may not ever envisage being in a position to have charity tribunal proceedings, so it may not be widely applicable to you. Hopefully, it's not needed at all. Next slide. So to cover some sort of final smaller points here, there's updates in relation to giving public notice to written consents and orders of the Charity Commission under various sections of the current Charities Act. So most notably, there's a new section which gives Charity Commission a discretionary power to require public notice or to require the trustees of a charity to give public notice of amendments to their governing document where Charity Commission consent is sought. This may lengthen the procedure, as you can imagine, for approval of changes to the charity's governing document if a certain specified time period of public notice is required before the Charity Commission will then consider any responses to the public notice before they will then consider granting the changes to the governing document. In practice, though, this may, in reality, be putting on a statutory basis what the Charity Commission already does in certain areas. So, for example, the Charity Commission might currently require consultation in some cases before giving consent to change of objects or to spending permanent endowments, where those are particular big issues or high-profile charities. And we don't currently know, based on the current information from the Charity Commission, how long that public notice period might be. So it's a case of waiting and seeing what further guidance the Charity Commission publishes in relation to this particular change. Finally, there are some sort of minor consequential amendments to the Act and to various provisions, sort of minor issues there, and they're all set out in the schedules to the Act and can be seen if you go on the Charity Commission website to look at the incoming changes, but we don't propose to go through each and every one of those on the webinar now. Okay, next slide.
Okay, so that's a quick run through the changes that were coming through this September. And I hope that gives an idea of both the changes you need to be thinking about now and also perhaps some of the things that you can do in response to them. We'd also invite you to have a look out for sources of further information. Obviously, the Charity Commission and its trustee news. Some of you will be receiving that already. Do keep an eye out for announcements about further guidance. Watch out also for the review of financial thresholds, which has been announced. And as we said at the beginning, we've got further webinars planned for both March 2023 and then in October to catch the next two implementation thresholds. I hope this is coming through to you, by the way. I gathered from the notes that you couldn't hear me using the headset. So apologies for that. And I hope that it's clearer without the headset. In any event, we'll be following on with those further events to ensure that you've got the information you need. And we hope that you'll offer some feedback about areas in which you think it would be worth having a particular focus, to things that you're particularly curious about. And I gather the audio is better. Excellent. Good. It only leads us to go on to the next slide and make the request of you that you let us know if you've got any questions. While people are thinking about that, I gather that at least some of you didn't hear what I said earlier about the rules regarding governing documents. And so there are going to be changes to the rules on making changes to governing documents, in particular to objects. That the changes are to harmonise the approach taken across legal structures. We'll get the details in autumn 2023, so that's in the last tranche of changes. And essentially, what will be happening is that the Commission will take a unified approach. It will look at the current objects. It will look at whether there's a good reason to change those objects while keeping them as close as possible to the current objects. And it will look at whether the new formulation is appropriate to provide suitable and effective objects for the charity in light of current social and economic circumstances. I hope that came through this time round. And again, sorry for the sound quality issues.